Judgment in the matter of Commissioners of His Majesty's Revenue and Customs against BlueCrest Capital Management.
Lady Simler will explain the Court's reasoning.
This appeal concerns how members of certain partnerships are taxed. The Limited Liability Partnerships Act 2000 created a new type of business structure, the Limited Liability Partnership, which shields its members from personal liability in relation to the partnership, while at the same time giving them the same tax treatment as partners in a traditional partnership, even when their actual role more closely resembled that of an employee. This applied even where members received fixed salaries, had no say in how the partnership was run, and bore no risk if it made losses. This was widely seen as unfair and as an opportunity for tax avoidance. To address this, the Finance Act 2014 introduced 3 new conditions, known as Conditions A, B and C, now found in Sections 863A to 863G of the Income Tax Trading and Other Income Act 2005. Each condition targets a different hallmark of what the legislation calls disguised employment. An LLP member who satisfies all 3 conditions is taxed as an employee rather than as a partner. Conversely, failing any one condition means that the member of the LLP continues to be taxed as a partner. This appeal concerns Conditions A and B. Condition A looks at the nature of a member's pay. It is satisfied if their remuneration is fixed, or variable but is varied without reference to the partnership's profits or losses, or not in practice affected by the overall profits or losses. Condition B looks at a member's influence. It is satisfied if the LLP agreement does not give the member significant influence over the affairs of the partnership. Condition C concerns a member's capital contribution to the partnership, but it is not an issue here. The appellant, BlueCrest Capital Management, UK LLP, is an investment management business that primarily manages money on behalf of the co-founder of the wider BlueCrest Group. In 2014, BlueCrest had 82 individual members, most of whom were investment managers. Several BlueCrest Group companies were also corporate members. BlueCrest's individual members carried significant responsibility, including making multi-million-pound investment decisions, but they had little say over how the LLP was run. The partnership was run by its board and executive committee. Members had a right to be consulted on strategic matters and to vote on changes to the nature of the business or certain exceptional transactions. However, each individual member had only 1 vote, while a corporate member, BlueCrest Capital UK Limited, had 100 votes. Since there were fewer than 100 individual members, they couldn't outvote the corporate member, even if they voted unanimously. HMRC determined that the vast majority of BlueCrest members met all 3 conditions and should therefore be taxed as employees. BlueCrest challenged that determination, arguing that its investment managers failed Condition A because their pay was tied to the LLP's profits, and Condition B because placing large trades meant that they exercised significant influence over the LLP's affairs. The first-tier tribunal agreed with HMRC on Condition A, finding that members' income was in substance a disguised salary. On Condition B, however, it found that the more senior investment managers, those managing capital allocations of at least $100 million, and desk heads, did have significant influence over the LLP's affairs, and so failed that condition. Both sides appealed to the upper tribunal, which upheld the FTT's reasoning and conclusions. Both sides then appealed to the Court of Appeal, which found that the FTT had applied Condition B incorrectly. The Court of Appeal held that the FTT had wrongly considered members' informal or de facto influence derived from their roles and performance, when the legislation requires that the relevant influence must flow from the members' formal legal rights and duties under the LLP agreement. Like the tribunals, the Court of Appeal rejected BlueCrest's arguments on Condition A. BlueCrest then appealed to this court. We unanimously dismiss BlueCrest's appeal. Lord Richards and I give the judgment with which Lords Briggs, Hamblin and Burrows agree. We hold that the BlueCrest members meet Condition A and that the FTT was wrong to conclude that the relevant investment manager members failed Condition B. Our reasons in relation to Condition B are, in summary, as follows. It is met where the mutual rights and duties of the members of the limited liability partnership and the partnership and its members do not give a member significant influence over the affairs of the partnership. The condition is concerned with legally enforceable rights and duties that derive from the LLP agreement or the statutory framework. Informal influence, whether derived from strong performance, personal reputation or relationships, is simply not relevant. That approach reflects established case law on traditional partnerships. What distinguishes a partner from an employee is the formal scope of their role in the management of the business, not how successful they happen to be. On the meaning of significant influence over the affairs of the LLP, the test requires influence, not outright control. But that influence must be meaningful in a commercial sense, and it must relate to the affairs of the partnership viewed as a whole. In practice, this means that a member is likely to have significant influence only if they have a voice in high-level or strategic decision-making about the partnership's affairs, or at least an ability to shape such decisions. Day-to-day operational decisions are unlikely to qualify, and less still if they relate only to one part of the business. Making high-value investment decisions by itself does not amount to significant influence over the LLP's affairs. Applying these principles, we conclude that the FTT did misapply Condition B. Rather than focusing on members' rights and duties under the LLP agreement, the tribunal focused almost entirely on members' influence derived from their personal qualities and their activities. It barely engaged with the terms of the LLP agreement itself. There were other material errors too, which individually and collectively undermined the tribunal's analysis. The Court of Appeal was right to send the case back to the FTT for reconsideration. On Condition A, our reasons are in summary as follows. Condition A is met where it's reasonable to expect that at least 80% of the total amount payable to a member in the relevant period will be disguised salary. Disguised salary means remuneration that is either fixed or is variable but varied without reference to the partnership's overall profits or losses, or is not in practice affected by those profits or losses. Most of the relevant BlueCrest members' pay took the form of discretionary allocations, calculated primarily by reference to the performance of their own individual investment portfolios, rather than by reference to the LLP's overall profits. BlueCrest's policy, however, was that total profits for any given year acted as a ceiling on total discretionary allocations. If total profits fell short of total allocations, the allocations would be reduced proportionately. In practice, this cap was never triggered because BlueCrest was consistently profitable. BlueCrest argued, however, that the profit link cap meant that members' discretionary allocations were varied with reference to the LLP's overall profits, so that members failed Condition A. We reject that argument. Condition A is designed to capture one of the defining features of a genuine partnership, that profits and losses are shared among the partners. Receiving a share of the returns generated by your own work, subject only to a cap linked to the firm's total profits, does not reflect that characteristic and would not in ordinary terms be recognised as a partnership share. It would not fulfil Condition A's purpose, which is to distinguish between what is typical pay for a partner and what is typical pay for an employee. While BlueCrest's argument might seem superficially plausible on a purely literal reading of Condition A, it is so far removed from the provision's purpose and from any natural reading of its language that it must be rejected.